Welcome to Harney's Offshore Litigation Podcast. I am delighted to have with me here William Peake, partner in our London office. William, how are you?
Yeah, great. Thanks, Ian. Delighted to be back.
We are going to discuss today this interesting case handed down on the 20th of August, 2021 by Justice David Doyle called Global Fidelity Bank, involuntary liquidation at the time of the application. And it's all to do with what I often used to describe as the invidious practice of challenging the mere identity of a liquidator. But in fact, that's too simplistic because sometimes there are very good reasons to challenge the identity of a liquidator as long as it's not sort of facile and limited only to her identity. Isn't that right, Will?
Yeah, I think that's absolutely right. And actually picking through the rubble of this judgment is actually a fantastic exercise because there's so many offshore topics that come into very sharp focus. And I think it's really worth taking a canter through some of those key issues. And in your opening gambit, you specified the date of the judgment. And dates in relation to this case and its factual matrix are extremely important. And the judge puts a real significance as to the dates of the JVL's engagement, the date of the JVL's draft report, and the date of the JVL's final report. I think it's worth focusing on the fact that the court acknowledged very, very quickly that the JVLs entered into open and transparent communications with the stakeholder base.
Absolutely.
And they adopt a neutral position. They go so far as to say in those communications that a depositor in the bank has opposed our appointment. So it is fair and square.
Yeah.
There is an issue there to all of the stakeholders and all of the creditor base. And the court then goes to put significance in relation to the fact that there was one dissenting creditor. And actually on the eve of the application where this issue was going to be dealt with, another significant creditor actually came forward and said that they have no objection to the JVLs continuing in their role as official liquidators.
Yeah, exactly.
And this is important in the context of what is the purpose of the official liquidation? It's to resolve and deal with the issues arising for those with the economic interests. And there has to be an objective analysis of that. And the views of all of those creditors are relevant. And I think it might be helpful to pause there to sketch out the three key aspects that frame the judgment going forward. And if for no other reason, Ian, than to stop me talking.
Well, not at all. I mean, the setting out this background is so important. And as you say, it's something that occurs for us as a firm every week or month, and that we have to decide when clients ask us, well, what about the objectivity of this liquidator? Should we propose this liquidator? Is there any reason to object? As liquidator? And of course, it depends on the law, the objective findings of the court as to whether there could be any reason why the official liquidator is not doing her job, both that as a factual matter and then the appearances as well as previous history. But so often it is a stakeholder's ignorance, actually, of the process, of the fact that these are licensed practitioners. This is the Cayman Islands case, we're talking about the Cayman Islands. And as Justice David Doyle puts it at the very end of his judgment, these are licensed practitioners who have a deep, deep interest in, quote, wishing to preserve their professional reputations in the mind of the courts and others. It is not naive, wishful thinking or unrealistic to state that confidence can reasonably be placed in them. Now, listen, this is paragraph 90, so he's gone through all the reasons why, of course, there's no issue here. But that driver of them being licensed, their professional reputations, the need for future work based on their previous credibility, and the fact that they are officers of the court is something that I think practitioners have a duty to explain to their clients, actually, before making any silly application. Now, I should just let you go back to that main point, but I just wanted to comment also that I read this judgment over and over. It's so interesting, and I'd recommend to anyone to read it. But in the middle paragraphs, 31 to 40, were actually taken through some of, let's call them, the previous generation's most interesting international fraud cases. We have dicta from the Maxwell fraud case. The Daily Mail once described him as the crook of the century, who managed to use £90 million worth of a pension fund's assets for his own benefit to prop up his own share price. We have the further case of Polypec, which those of a generation in the 1990s remember. I think the only case missing of the 1990s is BCCI and this reportage.
Yes,
so it's quite a read, actually. It's a great judgment.
Yeah, no, absolutely, and it is a greatest hits of cases that law students actually will recognise. And it's interesting that in relation to the Cayman judgments that are relied on, again, we see Tangerine being relied on. We see the Alpha case. We see the first architects of Cayman's financial services jurisdiction. We hear from Jones, we hear from Foster, we hear from Quinn, and they are the individuals who shaped and formed Cayman as a jurisdiction, made it the creditor-friendly jurisdiction that it is. And just picking up actually Ian, on your point of individuals guarding their reputation, because we are all, without your reputation, you are nothing. And I'm sure there's a much more pithy Descartes quote for that. But in relation to actually the next paragraph of paragraph 91 of the judgment, where Mr. Justice Doyle actually gets into the fact that this is important to the jurisdiction. We're all ambassadors for the jurisdiction. And unless somewhere like Cayman, that is a financial services hub, has a competent and functioning and effective insolvency regime, that the regime itself will not work, that the jurisdiction is impacted by that. And that goes to your point, Ian, of think long and hard before making these applications. Think long and hard as to who is being scrutinized, what professional services. But just going back to the actual case, that you can strip away a lot of the necessary trot through the common law jurisdictions, and it can be reduced into the three principles from Mr. Justice Jones in the 2013 Hadar case, whereby it turns on, first of all, you have to identify the facts of the prior relationship and the involvement. That's why the timing is so important in relation to the short duration and the limited issues that the JVLs looked at, and that they were engaged the 9th of July. They produced a draft report on the 14th of July. On the 16th of July, they produced a final report which hadn't been amended. That's a very, very tight window.
Very, very tight. And it sort of echoes the use of the administration procedure through an administrator in a different context, of course, in the UK. And it's absolutely not unusual for an administrator or proposed administrator to be looking at a contingency plan or doing some work for secured creditors banks to see, what the state of the company is in. And the judge actually quotes Lightman and Moss, and it just where it says the proposed administrator will ordinarily undertake an investigation of the company's affairs and financial position, and consequently offer advice before being appointed, which will include advice on the timing and manner of appointment. And I say that to our liquidator proposed appointees. Yes, you have to be extremely careful, but no, it is not the law that you may not have any involvement and may not communicate. That just isn't correct, but I think there is a sense in the community that a proposed appointee has to be an absolute stranger to the balance sheet, as it were, of the company, which in and of itself can actually present a difficulty, because then that appointee has zero previous involvement or understanding, and in some limited circumstances, previous dealings can create efficiencies.
Yeah, and for example, Barclay Applegate relief, those judgments actually speak to work done in the past. There's an acknowledgement that there may be a learning curve, that there may be useful work done. And this is what the judge has to actually look at and balance up, whether there are pros and there are cons. And Mr. Justice Foster in the Tangerine judgment specifically identified that. So there does need to be a nitty-gritty analysis of that prior relationship before you move on to limbs 2 and 3 of the Hadar test. And the second limb is you need to determine if the existence is capable of impairing the appearance of independence.
Yeah.
And And our blog actually touches on that point very, very quickly in relation to the optics. And I always remember that, Mr. Justice Jones, I think he says it just appearance matters. And the optics in and around that could possibly fetter the abilities of the office holders to do their work properly.
It's massively distracting if half of the stakeholders with an economic interest in the outcome believe that their liquidator is in fact biased in some way. It could be very bad for the disposition, the final resolution of the liquidation, actually.
Absolutely. And it's absolutely opposite that the most impeccably attired individual that I ever worked with, Mr. Justice Jones, should say that appearance matters. He always had an amazing ability to make me look like a bedraggled street urchin. And then the next limb of the test is that if you are able to determine that existence of a possible optical infringement of independence, you need to determine if it is sufficiently material to the liquidation that a fair-minded stakeholder could reasonably object. So with those in play, Mr. Justice Doyle then applies the law to the facts. And there's also a beautifully global feel to this judgment in terms of the common law analysis and in terms of Mr. Justice Doyle previously sat in the Isle of Man. And he looks at this specifically from an Isle of Man perspective, but also it's really interesting to see it in the Isle of Man context. He says, I recall referring to the Cayman cases, to the common law cases, and you get that truly multifaceted common law approach. And it really does just go to show how all jurisdictions which have insolvency law as a key aspect of their armory, they all have the same issues. These are common denominators. And that's why there is so much law on the topic.
And I think, without getting too philosophical, but I think earlier in the podcast, you did ask me to think deeply. There is a risk in any legal system that actually what we all take for granted as good controls to ensure the objectivity, the good fiduciary behavior of our office holders is durable. But as we can see, that isn't always the case. But all of these legal principles, the institutions that keep these principles of fairness and objectivity serving the stakeholders must be maintained rigorously by the courts and practitioners. It's all very delicate. When it goes wrong, it is horrendously bad for confidence in the court system, for insolvency and construction.
Absolutely. And those duties hover constantly throughout the life cycle of the matter. They are amplified at certain times, for example, at the appointment stage, but they sit as a golden thread throughout the case. And it is independence, conflicts, they're all litigation strategies that are adopted, and they have to be minded, and you're a custodian of those throughout the life cycle of the matter. And we are all officers of the court. Yeah. We are shoulder to shoulder with the insolvency appointee on those issues. And that is what gives people the confidence and the, frankly, desire to do their business in those jurisdictions.
I think that the most difficult cases and where this issue comes into sharpest refraction is in fact not in this particular case of Global Fidelity Bank. Yes, I think it's the cases that scare me the most actually are those provisional liquidation cases where a company is seeking an appointee in light touch PL such that the management and the proposed JPLs will be working together in the future. And then you have this battle for which appointees should be preferred. And the accusation is, well, of course, management has gone to the person that they think will be the softest touch in the light touch liquidation. And, the management has no doubt been given soft assurances in some way through some course of conduct or whatever. And the creditors say, we want someone completely independent. And some creditors say, well, actually, we don't mind because that person's been on the ground for a long time. And then we always go back to the argument, we should say, well, these are all professionals. It's very invidious to be arguing about which one has a better reputation. It's really ugly. But on the other hand, I think clients misunderstand that and they think they're seeking to obtain some advantage. And actually in this judgment, CW Group is cited as you would expect. And the recent Adamas Asia Strategic Opportunity case also there. So I think my own view is that is where we are at greatest risk of bad things happening, of management wishing to obstruct rather than facilitate an efficient liquidation process, presumably because of anxieties as to where that process will lead, is what Ian Caveley, Justice Caveley, notes in the Adamus Asian Origin Fund. I think he's absolutely right in that particular case, and something constantly for us all to be very, very careful of.
Yeah, I couldn't agree more. But I think it does go back to the common denominator principles. That if you were approaching the factual matrix in relation to the provisional liquidation context, these principles still apply, and you need to not lose sight of that. And if these were two exam questions, this first one is straightforward. And the judge comes out and says that. He actually explicitly says this is not finely balanced. And makes his conclusions. But if the provisional liquidation context, where you have a insolvency practitioner inveigled with management, that then leads to a scrap over the official appointments, that's a much more challenging exam question. Probably has.
Listen, you always know which cases are going to be those cases, because of course it's the cases where the company that wishes to restructure itself, badly advised maybe, decides to do the whole thing secretly. They don't inform stakeholders that they intend to apply to put itself into PL. They don't give over the books and records in an open way. Of course, a company-driven restructuring has to be the most open process you can imagine to bring the economic interest holders on board. And it's those kind of clandestine applications where they just get the messaging, the PR, the transparency all wrong, that of course, the reaction is going to be, well, we're not letting you use your guy. So you can almost predict it.
Absolutely. And it goes back to one of the, my opening points, that open and transparent correspondence and communications between the professionals who people have put trust and confidence in those individuals to resolve the issues of the company that they have an economic interest in. There has to be open, transparent and frank communications. And that's why this case is a paradigm example of no attempt was made to better a hand. The hand is the hand. And that is the approach they take. And it's utterly objective. And the judge acknowledges that and allows that as the kind of the zephyr of good practice upon which to reach a swift conclusion that it's not finely balanced.
In fact, it's a bit more than the zephyr of good practice. It's actually the law, isn't it, as set down by Mr. Justice Hoffman in the common law in Roselmar. I mean, it's saying basically a voluntary liquidator in such a situation where the liquidation is going to become compulsory ought to just sit back and say, up to you, everyone. We're here to help. I didn't know that until I read this case.
Yeah, it's a really worthwhile exercise going through this case in fastidious detail, because it does remind you of so many pertinent authorities, and it does just a wonderful job of weaving together all of the jurisdictions and then reducing them into key takeaway points and then reaching the conclusion.
Anyway, thanks so much, Phil. I really enjoyed that. Thanks. It's really good.
Yeah, absolutely. That was very good fun.
And I should just say to our audience, thank you very much for joining us, and do visit us on harness.com. You can find our podcasts and blogs and subscribe to the same if you wish. Thank you very much.